If you possess a green card or you are acquainted with someone who does, there is one question that arises over and over, and it is more pressing in 2026 than it has ever been previously. Can you genuinely forfeit your green card simply by traveling overseas for an extended period? The response is yes, you absolutely can. And currently, with enforcement at the border, stricter than it has been in years, the regulations surrounding international travel for lawful permanent residents have never carried greater importance. So today we are going to walk through precisely what those regulations are, what has shifted recently, what boundaries you need to monitor carefully, and most critically, what actionable measures you can take immediately to safeguard the standing you labored so diligently to obtain. Whether you are arranging a trip to see relatives, tending to an elderly parent overseas, or you are already outside the United States and feeling uncertain about your circumstances, remain with us through this complete video. What you discover today could create a meaningful impact. Let us begin with the groundwork because comprehending this matter thoroughly means grasping one essential legal principle: abandonment of permanent resident standing. When the United States awards you a green card, it awards you the privilege to reside and work here indefinitely. But the law additionally requires that you genuinely establish the United States as your permanent residence. That term permanent is not merely a technicality. It holds genuine legal significance. If the government determines that you no longer plan to reside in the United States as your principal place of dwelling, it can conclude that you have relinquished your standing as a lawful permanent resident. And when that occurs, you can forfeit your green card. Now, how does the government reach that conclusion? The fundamental question immigration officers are posing when you come back from a journey overseas is straightforward but sweeping. Is the United States genuinely your residence? Not merely a location you pass through occasionally, but your true permanent dwelling place? And the duration of time you have spent outside the nation is one of the most critical indicators they examine, although it is far from the sole one. According to USCIS, the U.S. Citizenship and Immigration Services, the standard benchmark is whether you have been absent from the United States for longer than 1 year. If you have been away for over 12 months without any specialized protection established, there is a legal assumption that you have abandoned your permanent residence. That assumption can be rebutted, but it transfers the responsibility onto you to demonstrate that you did not plan to surrender your residence here. And surmounting that responsibility is not always straightforward, particularly in today's enforcement climate. But here is something that catches many individuals off guard. The 1-year threshold is not a magical boundary of complete safety beneath it. USCIS has been explicit that abandonment can be established, even in journeys shorter than 1 year, if the circumstances suggest you no longer plan to establish the United States as your permanent residence. So someone who undertakes a 6-month journey then comes back to the U.S. for merely a couple of weeks, and then departs again for another 5 months may encounter serious inquiries. Not because any individual journey surpassed 12 months, but because the collective pattern of their travel implies they are residing overseas and visiting the U.S. rather than residing in the U.S. and traveling periodically. Immigration officers examine the entirety of your circumstances. They examine trends over time, not merely the most recent journey. This is why immigration professionals frequently reference 6 months as a practical caution boundary. Journeys under 6 months are typically regarded as lower risk, and usually do not trigger abandonment concerns provided you are preserving your connections to the United States. But once you surpass that 6-month boundary, you enter territory where a U.S. Customs and Border Protection officer, a CBP officer at the port of entry, may start to pose tougher questions. Between 6 months and 1 year, you are in what numerous attorneys characterize as an uncertain zone. You will probably be permitted entry, but you may encounter heightened scrutiny, additional questioning, and the necessity to prove your connections to the United States. Beyond 1 year, circumstances become considerably more challenging, and the danger of severe immigration repercussions escalates dramatically. What precisely do officers examine when they are evaluating your circumstances? According to official USCIS direction, they weigh factors such as whether you preserved U.S. family and community connections during your absence, whether you retained U.S. employment, whether you continued submitting U.S. income taxes as a resident, Whether you preserved a U.S. mailing address, whether you maintained U.S. bank accounts and a current U.S. driver's license, and whether you hold property or operate a business in the United States. None of these factors is singularly conclusive. What counts is the comprehensive picture they create. Collectively, these factors narrate the story of whether the United States remains your genuine residence or whether you have essentially relocated overseas. And here is something that numerous individuals disregard, and it is critically significant. How you submit your taxes counts. If you have ever identified yourself as a non-resident on your federal income tax filing, that can be employed against you in an abandonment assessment. The USCIS Adjudicator's Field Manual clarifies that filing as a non-resident, essentially informing the IRS that you reside overseas, can be construed as evidence that you do not regard the United States as your permanent residence. This does not suggest you should submit inaccurately or engage in tax fraud, but it does suggest that tax choices and immigration choices are profoundly intertwined, and you should evaluate them jointly, preferably with both a tax specialist and an immigration attorney. Now, let us discuss what has shifted specifically in the present climate, because this is where matters become especially significant for green card holders intending to travel in 2026. The enforcement terrain has altered substantially over the preceding year. As NPR documented, CBP has indicated that green card holders who have not violated any U.S. statutes, committed application deception, or neglected to apply for a re-entry permit after extended travel have nothing to worry about at the border. That is comforting, and it highlights precisely what you must have arranged: your paperwork, your proof of U.S. connections, and your re-entry permit if your journey will surpass 12 months. But here is the situation on the ground. According to coverage and legal direction circulating through 2025 and into 2026, CBP has been performing more comprehensive inspections at ports of entry. Officers are more regularly posing detailed questions about the length and reason for journeys, examining travel history with increased diligence, and in certain instances performing secondary inspections that can extend several hours. A new biometric entry-exit framework introduced by the Department of Homeland Security, which became effective December 26, 2025, now mandates most foreign nationals, including green card holders, to undergo biometric identity verification, primarily facial recognition imaging, when entering and leaving the United States. This signifies your travel record is being documented with superior accuracy than ever previously. If you claim your journey was 3 months, but the records indicate something different, that inconsistency will be detected. Furthermore, Presidential Proclamation 10998, which became effective January 1, 2026, broadened certain travel limitations and has influenced how ports of entry evaluate travelers associated with affected nations. Green card holders from those nations remain legally exempt from the travel prohibition itself, meaning it cannot revoke your green card, but it has added to a wider atmosphere of elevated scrutiny that impacts the re-entry experience for many permanent residents. If you are a green card holder from a nation presently under any degree of limitation, you should be particularly meticulous in arranging your paperwork before any international travel. So, what do you practically do? What are the tangible measures accessible to you? Let us walk through them methodically. The most effective instrument accessible to a green card holder who understands their journey will surpass 12 months is the re-entry permit. A re-entry permit is a travel document granted by USCIS on Form I-131. It remains valid for up to 2 years and functions as compelling evidence that you plan to preserve your permanent residence in the United States, even while spending a prolonged period overseas. It prevents your green card from being automatically regarded as invalid after a 12-month absence. As of 2025, the submission fee for a re-entry permit is $630, and processing durations have spanned from approximately 8 to 12 months, though certain USCIS service centers have required longer. This indicates you must apply considerably in advance, and crucially, you must be physically located in the United States when you submit. You cannot submit for a re-entry permit from overseas. If you anticipate an extended journey approaching, commence this procedure as early as feasible. It is additionally vital to comprehend what a re-entry permit does not accomplish. It does not ensure admission into the United States. A CBP officer can still question you and evaluate your circumstances upon arrival. The permit is compelling evidence of your intention, but it is not a barrier that eliminates all inquiries. You should still preserve your U.S. connections throughout your time overseas and be ready to articulate clearly why you were outside the nation for a prolonged duration. What if you have already been outside the United States for longer than a year without a re-entry permit? This is a predicament numerous individuals encounter, frequently due to situations they did not foresee: a family medical emergency, difficulties with foreign administrative systems, travel interruptions. If you are in this predicament, the route back becomes more complex, but it is not inevitably sealed. One possibility is to apply for what is termed a returning resident visa, or SB1 visa, at the closest U.S. embassy or consulate. This necessitates you to establish several things: that your departure from the United States was temporary, that you planned throughout to return, and that your prolonged stay overseas was produced by situations outside your control. The SB1 procedure includes a medical assessment and is authentically challenging to successfully complete. The State Department advises submitting at least 3 months prior to your expected return. If you find yourself in this predicament, please do not attempt to manage it independently. This is precisely the type of case where the direction of a qualified immigration attorney can create a tremendous difference. Now, let us consider naturalization for a moment, because this is linked in manners that some green card holders do not completely recognize. Even if you effectively return to the United States after prolonged travel overseas and your green card standing is undamaged, extended absences can interrupt the continuous residence obligation for naturalization. Broadly speaking, to become a U.S. citizen, you must exhibit 5 years of continuous residence after obtaining your green card. A solitary absence of 6 months or longer can prompt questions about that continuous residence, and an absence of 1 year or longer can sever it completely, unless highly particular exceptions apply. If you have been organizing your naturalization schedule and you undertake an extended journey, that timeline may effectively restart for purposes of the continuous residence computation. If maintaining your route to citizenship is significant to you, incorporate that into your travel preparation. There is additionally a form that some green card holders are not informed about. Form N-470, the application to preserve residence for naturalization purposes. If your absence is 1 year or extended and you wish to safeguard your continuous residence for citizenship purposes, you may be able to submit Form N-470 under specific qualifying conditions, such as employment with a qualifying U.S. employer or organization overseas. Consult with an immigration attorney about whether this alternative might pertain to your circumstances. Let us additionally devote a moment to the situation that arises perhaps more frequently than any other: the crisis journey. An elderly parent becomes critically unwell. A sibling experiences a medical emergency. A natural catastrophe damages a family residence. These situations are genuine. They are profoundly human, and they do not accommodate anyone's immigration schedule. If you are a green card holder and you encounter a crisis that demands prolonged time overseas, the most crucial action you can take is record everything. Preserve hospital documents, medical correspondence, interactions with local officials, any documentation trail that illustrates the involuntary character of your prolonged stay. When you are ultimately able to return, that documentation becomes your proof of honest intention. You were not forsaking the United States. You were answering a genuine crisis. Officers at the port of entry can and do weigh these situations, particularly when they are thoroughly documented. Let us additionally examine something that frequently catches individuals off guard: the trajectory of travel over time. Picture someone who undertakes a 5-month journey, returns home for several weeks, then departs again for 4 months, comes back briefly, and departs once more. No solitary journey surpasses 6 months. Yet the comprehensive trajectory creates an image of someone who is seldom in the United States. Someone for whom the nation may no longer represent the focal point of their existence. USCIS and CBP weigh precisely this type of trajectory when evaluating your circumstances. They examine not merely whether you surpassed any individual boundary, but whether the United States is authentically where you reside. If your trajectory of travel implies otherwise, You may encounter inquiries even if your separate journeys appear acceptable in isolation. So, what can you accomplish right now? Irrespective of whether you have a journey arranged, commence by assembling your proof of U.S. connections. Evaluate what you possess: a lease or mortgage bearing your name, U.S. bank accounts, a current U.S. driver's license, tax filings submitted as a U.S. resident, employment documentation, community memberships, children registered in U.S. schools. All of these elements narrate a story about your existence here. Maintain them current, maintain them structured, and maintain copies within reach. If something transpired and you required to walk into a port of entry and establish that the United States is your residence, what would you present them? Next, examine your green card itself. Is it expired or approaching expiration? As of 2025, CBP has been implementing documentation verifications more stringently, and an expired green card can produce difficulties at the border, even if your standing remains current. Green cards are typically renewed on Form A90, and if yours falls within 6 months of expiring or has already expired, address that before traveling. An I-551 stamp in your passport, which USCIS can supply, can function as provisional proof of your standing if you must travel urgently and your card circumstances are unresolved. Before any international journey, especially one that might stretch past 6 months, seek counsel from a qualified immigration attorney. This is not fear-mongering, it is wisdom. An attorney can assess your travel record, appraise your circumstances candidly, counsel you on whether a re-entry permit is suitable, and assist you in assembling your paperwork. Immigration law carries genuine intricacy, and the distinction between being equipped and being unequipped at a port of entry can be consequential. One additional point worth stating directly: if you carry any previous immigration infractions, any previous criminal matters, even minor ones from years past, speak with an attorney before traveling internationally. As of 2026, CBP's databases are surfacing old records with increased regularity, and what might have appeared like a settled matter previously can generate difficulties at a port of entry today. The optimal time to comprehend your vulnerability is before you travel, not afterward. Let us consolidate this with a transparent picture of where matters stand as of April 14, 2026. The fundamental regulations for green card holders and international travel have not essentially shifted. The legal structure surrounding abandonment of permanent resident standing has been established for years, grounded in USCIS direction and immigration statute. What has shifted is the vigor and meticulousness of enforcement. Biometric monitoring is more thorough. CBP officers are exercising greater scrutiny toward returning permanent residents, especially those with prolonged absences. The political and regulatory climate has driven border agencies toward more rigorous application of existing regulations. Holding a green card remains a robust legal standing with meaningful protections. CBP cannot nullify your green card instantly, and only an immigration judge can officially terminate your permanent resident standing. But the process of re-entry has grown more rigorous, and the significance of being equipped has expanded correspondingly. Before we conclude, let us be absolutely explicit about something significant. Everything we have examined today is designed to serve informational purposes exclusively. It is not legal counsel, and it cannot replace the counsel of a qualified immigration attorney who understands the complete specifics of your individual circumstances. Immigration policy can and does shift sometimes rapidly, and what is precise as of the date of this video may be affected by forthcoming developments. Always confirm the newest information with authoritative sources. The USCIS website at uscis.gov, the U.S. Customs and Border Protection website at cbp.gov, and the Department of State's website for consular and visa affairs. And for your individual circumstances, please collaborate with a licensed immigration professional. On screen, please observe this concise disclaimer. Immigration policy can shift. The information in this video mirrors conditions as of April 14, 2026. Always consult authoritative sources and a qualified immigration attorney for your particular circumstances. If this video assisted you in grasping something significant, If it provided you clarity or assisted a relative in feeling better equipped, that is precisely why this platform exists. Here at US Updates Hub, our purpose is to deliver transparent, candid, balanced information about the US immigration system so you can render educated choices about your personal life. We do not dramatize. We do not propagate anxiety. We provide you facts, perspective, and direction because you are entitled to comprehend the regulations that influence your existence and your prospects. So, please, if this video proved beneficial to you, give it a like. It authentically assists other individuals in discovering this material when they require it most. Forward it to a companion, a relative, or anyone you are acquainted with who possesses a green card and travels internationally. And if you are not currently subscribed to US Updates Hub, press that subscribe button now and activate your notifications because we release new videos consistently on the subjects that matter most to immigrants and permanent residents throughout the United States. The immigration terrain is evolving, and we are here to assist you in navigating it with assurance. Examine the description section beneath this video for connections to official USCIS materials, information on Form I-131 for re-entry permits, the USCIS processing time instrument, and direction from CBP on international travel as a permanent resident. Those materials are available for you whenever you require them. Thank you for being part of this community. You belong here, and we are here for you. Look after yourselves. Look after one another.